Good morning, good afternoon, good evening, depending on your geographical location. This is going to be a reaction video on an interview that was done with Mr. Zungula. Mr. Zungula is a member of the National Assembly in South Africa. He had been one of the complainants against the President of South Africa, Mr. Cyril Ramaphosa, that he had violated the Executive Members Ethics Act of 1998, otherwise known as EMEA. Let's hear the interview.
Let's get some reaction now on the Phalaphala report with ATM President Vuyo Zungula. Mr. Zungula, appreciate your time on the show today. Now, as a member of the opposition, what is your response to the acting public protector's clearance of President Cyril Ramaphosa of any wrongdoing in this whole Phalaphala saga?
Look, it is a betrayal of the intention of the creation of that Chapter 9 institution, because a Chapter 9 institution such as the Office of the Public Protector is there to basically protect the public from political individuals or the people that have got political power who abuse their political power for whatever reasons. However, what we've seen in our country when it comes to any scandals that have got something to do with the political parties or political individuals is that it is always the officials that take the blame. In Waterkloof, the same thing happened. Even now, the same thing is happening whereby, in accordance to the Deputy Public Protector, Mr. Ramaphosa is just an innocent person who saw nothing, did nothing. The only guilty person here, it is the General, Mr. Rhode. Whereas in his own affidavit, Mr. Rhode does stipulate that he was brought into the hotel of the president. He was informed about the crime, and he was given instruction to deal with the matter. So anything that flows from the actions of Mr. Rhode stems from that instruction that was given to him by his political principal, which is Mr. Ramaphosa.
Well, he's accused of having overstepped his authority, if you will.
Before he answers the accusation of Mr. Rhode having overstepped his authority, I would like to express that I 100% agree with Mr. Zungula's utterances thus far. Let's continue.
But I suppose the question is, how would he have known without being informed?
Look, it is him, Mr. Rhode, that is formed by the president. And the fact that even now, just recently, Mr. Ramaphosa went with other African leaders to Ukraine and Russia. Mr. Rhode was there, meaning all of the actions, meaning Mr. Ramaphosa did not see anything wrong with Mr. Rhode, because if he did, and if it surfaced in 2022 that these are the actions of Mr. Rhode, that he took a clandestine operation, used state resources, he abused people in the process. But the fact that he traveled with the president just a few weeks ago clearly shows that Mr. Ramaphosa is fine, is happy with Mr. Rhode being in his employ, being so close to him, because if he was not happy or he was not okay with him being so close to him, there's no way in which a person that is accused of using state resources to do a clandestine operation, you would keep them being in the presidential protection services. The fact that he's still there, meaning Mr. Ramaphosa, number one, was aware in 2020 and he gave his blessing, because there's no way a political an official would act without the instruction of the political principal, which is Mr. Ramaphosa.
Well, steps have been given.
Before the next question, I think it is important for me to point out that Mr. Zungula's point in this regard is unreasonable in this sense. When the president traveled to Ukraine with Mr. Rhode, that was in Russia, that was between the 16th and through to the 19th of June 2023. The Public Protector's report was issued on the 30th of June 2023, which is more or less about 1.5 to 2 weeks later. So the president could not have obviously anticipated that the report would come out finding a fault against Mr. Rhode. And the issue of suspending employees is very delicate an issue in that you need to prove that the employee concerned will interfere with the investigation in an event that they are not suspended. In this case, because there are two different offices here, the Office of the President and the Office of the Public Protector. The Public Protector is doing the investigation. So the investigation was not being done by someone in the Office of the President, wherein that person could be influenced by Wally Rhode, which then is a reasonable ground for the President not to have suspended him. I hope that is clear. It's unreasonable for this expectation for a simple reason. The Constitution of South Africa has something called the presumption of innocence until proven otherwise. So the president had to presume that Wally Rhode was innocent until he was proven otherwise. The validity of the assertions by Mr. Zungula only kicks in now that the Public Protector report is out, finding fault with Mr. Wally Rhode's conduct. Then if the president still carries on in that respect, then there would be a valid grounds to say, but the president is not taking the Public Protector seriously because the Public Protector has negative findings against Wally Rhode and he is still traveling with him everywhere as though he is promoting the unbecoming conduct that is alleged in the report of the Public Protector. Let us proceed.
60 days, I think, to act on Wally Rhode. How do you expect them to react?
Look, they are going to throw him under the bus. That is what is expected in all of the officials in our country. They are going to protect the political principle, and the one that is going to take all of the flag, it is Mr. Wally Rhode. Something that all officials should actually be worried about, that they are going to be used by the ones that have got political power. But when issues, come to this extent, it is them that will actually take the blame. It is them that will have their bad name and reputations, whereas they were acting via the instruction of the political principles. It's happened in Waterkloof. It is happening now, and God knows it's going to happen again to other individuals. Whenever that political principles are involved, it is always officials that are taken to this extent.
Well,
the reason why officials are taken to task is pretty simple, really, and it's ethics related. The Code of Conduct for the Public Servants states categorically in black and white that when an employee receives an instruction, one, it says if an employee receives an instruction, the instruction must be from an authorized person to give it. That's the first point. The instruction must be reasonable. The instruction must be lawful. The instruction should not violate the Constitution or any other law. So it is difficult to sympathize with people who would carry out or would go out and execute unlawful instructions. It's just that simple. So if Mr. Wally Rhode had been given an instruction by the president that was unlawful, it was his duty to say no. Now, of course, many people would say, how do you say no to the president? Well, perhaps that's the issue, because at some point in time, there are oversight structures. Parliament is one such structure to oversee the activities of the executive. So it is not unfathomable for all public servants that when they are receiving instructions which are unlawful, they must report accordingly. That is clear. So we shouldn't create an environment that there are gods within the public sector or any other office whose instructions have to be followed even if they are unlawful.
According to the acting public protector, a lot of the issues that were presented by Arthur Fraser are based on hearsay. He apparently refused to disclose the source of information. So it's conjecture, he said, she said. But the one thing that is clear is that President Cyril Ramaphosa, and a stand to be guarded, did confirm that he did have huge amounts of United States dollars within his premises, which were stolen by those that, with the aid of those that worked for him. We also know that he confirmed this. And according to records, in fact, there is no record of it with either SARS or the South African Reserve Bank. What's your take on that little bit of information?
Look, there are the facts, as you rightfully say. Number one, what is the issue? The first issue is that the president did not report a crime as required by Section 34 of PRECA. Now, Section 34E of PRECA lists the responsible individuals that ought to report a crime or any theft above 100,000 rands. And one of the listed individuals there, it is a member of a close corporation. Phalaphala is a trading name. It is a farm name. But the Ntabanyoni close corporation has only one member, which is Mr. Ramaphosa. So it is a fact You can't dispute that fact. The second issue is the issue of paid work. Paid work in the sense that Mr. Ramaphosa was...
Before he gets to paid work, I think I need to expose you to the stipulations of PRECA. Let's have a look at them. So here is PRECA to which Mr. Zungula is referring. You can see there is chapter 7, miscellaneous matters. And he's talking about paragraph 34, duty to report corrupt transactions. He says here in 34.1, any person who holds a position of authority who knows or ought reasonably to have known or suspected that any other person has committed an offense under part 1, 2, 3, or 4, or section 20 or 21, insofar as it relates to the aforementioned offenses of chapter 2, or B, the offense of theft, fraud, extortion, forgery, or uttering a forged document involving an amount of 100,000 or more, must report such knowledge or suspicion, or cause such knowledge or suspicion to be reported to any police official. There lies already a problem, but let us go to 34E, to which Mr. Zungula refers. So it says here, the manager, secretary, or director of a company as defined in Companies Act, and it includes members of a close corporation as defined, right? Now, why is this important? Because it says here, for the purposes of subsection 1, which we have read, the following persons hold a position of authority, and that is why Mr. Zungula quoted it. The manager, secretary, or a director of a company as defined in the Companies Act, and includes a member of close corporation as defined in the Close Corporation Act of 1984. Now, the president is a sole member in this close corporation, but the section 4, this section I'm reading here, for the purpose of subsection 1, the following persons hold a position of authority, doesn't end with paragraph E. Let's look at paragraph I. Any other person who is responsible for the overall management and control of the business of an employer. Did you hear that? Now, this becomes relevant in this sense. The president has employed a general manager to manage that firm. So basically, according to this very act, PRECA, it can be argued that the manager, the general manager, not the president, had to be the one reporting. Why? Because the president is the owner and has literally given the responsibility to manage the firm to that manager. And here's the other issue, the wording. I have a problem with the wording of this section to which he is referring, because this section says here, a person in if we read this paragraph where it says involving an amount of 100,000 or more, must report such knowledge or suspicion, or cause such knowledge or suspicion to be reported to any police official. For me, this opens up a door wherein the president says, well, I reported the matter to the police official. And it says any police official. It doesn't say with the exception of protection services. Do you see that? So this is how the president will get away with this. I'm not sure how Mr. Zungula missed that. As a matter of fact, when you look at the public protector's report, the public protector does say there that when she interviewed Mr. Rhode, Mr. Rhode indicated that the president reported this matter to him as a police official, meaning the president had discharged the requirements of PRECA. Can you see that? I do have a problem with the way this is written, but that's the law. We can do nothing about it. That's how the law as currently stands is written. Okay, let us go back then to the interview.
And mentally and physically engage in an activity that brings about, economic benefit to him and his close corporation, of which he's a sole member of. How did he do this? Number one, he went to the conference of the ANC in Limpopo. There he says, I'm a farmer, I sell and buy animals. That is an admission that is involved in paid work. Also, when he responds to the independent panel, he does stipulate that he's been involved in the day-to-day operations whereby he instructs money to be used, to be moved from one place to another. He instructs that these are the animals that need to be sold. Again, he further states that he knows of the potential buyers, meaning this person is actively involved in the running of that particular farm. But the public protector says there's no evidence to that regard. So it is in that spirit or in that mind, as the ATM was saying, that this report was drafted with the sole intention of protecting Mr. Ramaphosa from blatant facts, something that is clear even for a 10-year-old to see that, number one, Mr. Ramaphosa did not report a crime, whereas the legislation in terms of Section 34E of PRECA forces him to do so. Number two, he's been actively involved in the running of that particular farm, and also the issue of the risk of the conflict of interest, because on one side, you've got Wally Rhode, who is employed by the government to protect Mr. Ramaphosa. Mr. Ramaphosa has got something that is stolen on his personal property, but he instructs Mr. Wally Rhode. He does not instruct the general manager to say, you know what happens when we lose some of the animals and we need to, we need to open cases. He instructs a head of a protection services to deal with the matter, instead of saying to the general manager, deal with this in the very same manner that you deal with all of the other issues pertaining to either theft or whatever in our businesses.
There's a lot said here, and I do need to come in. I agree with Mr. Zungula when it comes to the president giving an instruction to Mr. Wally Rhode to go and investigate theft that took place in his private farm. Mr. Wally Rhode is a protection detail to the president given by the state for the purposes of protecting him as a president of the republic, not as a private citizen, nor is he given authority to go and investigate issues that are unrelated to his protection. Therefore, I agree here with Mr. Zungula. Even when it comes to what the president had done in terms of Section 96(2)(a) of the Constitution, which says you shall not enroll in paid work. Now, the public protector used a very narrow definition of paid work as it is stipulated in the Basic Conditions of Employment Act and Labor Relations Act, which talks about you selling your labor, receiving a compensation for it on a day-to-day operations and getting compensation for it. Now, the operative word being the president having to be responsible, or rather to be engaged in day-to-day operations. But that is narrow, as was argued by the Section 89 panel. And I'm more inclined to side with the arguments made by that panel. Let's just see some of those arguments, because I thought that they are quite valid. I'm not quite sure why did the public protector ignore them. Okay, let's start here. Meaning of the words undertake paid work. The Section 89 panel admits neither the Constitution nor Executive Ethics Act of 1998, as well as the Executive Code, define the words paid work. Nor have we found within the limited time at our disposal any case law which has considered these words. These words must be construed purposefully and teleologically in order to give effect to the provisions. The manifest purpose of Section 96 is to regulate the behavior or conduct of members of the cabinet by prescribing a code of conduct to which they must adhere. It does this by setting out conduct in which they may not be engaged. The expectation that members of cabinet are expected to devote their undivided attention to the constitutional responsibilities without any interference either from part-time or full-time employment or their business interest. Very important. They may not put themselves in a situation where there is a risk of a conflict of interest between their official responsibilities or their private interest. They may not act in a manner that is inconsistent with their office. This is a broad and an all-encompassing prohibition. It requires members of the cabinet in respect to their office and refrain. Let me read that again. It requires members of cabinet to respect their office and refrain from engaging in conduct that will detract from the integrity of the office they occupy. Their official position places members of cabinet in a position where they have access to information that others do not have access to, and they may be tempted to use this information to further their own private interests or that of their relatives or friends. and in the pursuit of their business interests, they may find themselves crossing the divide between the official and private interests. The prohibition on undertaking paid work must be seen in this context. When private interests are involved, they may be put to a choice of either following the proper procedures to protect their interest or use their office to pursue private interest. The provisions of Section 962 do not make an except where a cabinet member has declared his or her work. Precisely. It prohibits them from undertaking any paid work. We are unable to accept the proposition that a cabinet member is excused from complying with the provision of Sections 2A and 962A. Now, paragraph 90 is directly is an argument made by in fact, all these are arguments made by the Section 89 panel. And in paragraph 190, they are making an argument that is directly linked to paragraph 2 of the Constitution. Paragraph 2 of the Constitution reads as follows. It's called the supremacy of the Constitution. It says this Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. It is in this respect that this panel is making the argument they are making in paragraph 190. Paragraph 191. In our view, the provisions of Section 96(2)(a) puts a member of a cabinet to a choice. You either remain in business and do not become a member of cabinet, or you become a member of cabinet and relinquish your business interest during your membership of cabinet. The common thread that runs through all the conduct that a cabinet member may not engage in is to prevent abuse of power or abuse of office and interference with official responsibilities. That business interest may be declared, that business interest may be declared matters not, and I agree. Paragraph 193, I'm going to go as far as paragraph 195 just to conclude this aspect. We think that submission by the President has adopted a narrow view of the words paid work. We think the words paid work means work for financial gain or reward, whether as employees or self-employed. Had the drafters of the Constitution intended to limit prohibition to employment or business, they would have said so clearly. Instead, they used paid work, words of wider meaning. By way of comparison, the directives that are applicable to the public service refers to other remunerative work, which is true. They define these words to mean any business carried out or services rendered for gain or personal benefit by an employee outside of his or her employment in the relevant department for which remuneration is received. The word business is defined to include any business, trade, occupation, profession, calling, industry, or undertaking of any kind, or any activity carried out for gain or for profit by any person within the Republic or elsewhere, and includes all property derived from or used in or for the purpose of carrying on such other activity, and all rights in liabilities arising from such other activity. Paragraph 195, which is the one that I said I would conclude on with regards to this report. We see no warrant in limiting paid work to employment. In our view, those words include running a business. We think it would defeat the purpose of the provision to permit member of cabinet to operate a business and derive profits whilst prohibiting another member of cabinet from earning a salary. And I concur 100%. The public protector was unreasonable in considering paid work as narrow as she did.
Before we let you go, Mr. Zungula, one of the issues In fact, the reaction to this from other members of the opposition is very, very similar to yours. How do we expect you to move forward, and certainly are you going to be sitting down with other members of the opposition as parliamentarians to take this forward, or is this now done and dusted for you?
We as a party have already engaged our lawyers with a view of reviewing the report. Again, we've also had brief engagements with other leaders of other parties who share the same view that if we let this go, then it means South Africa will never be protected when it comes to the people that occupy political office. The fact that a person is president, is a minister, is premier, they are going to use their political power to actually commit crimes and evade accountability. That is our strongest view as the ATM, that when we fight for accountability in Phalaphala, we are fighting for principle, we are fighting for whoever occupies public office must exercise their power in line with what the Constitution requires and not abuse their powers.
Indeed, Mr. Zungula, indeed. Yours is a noble cause, which we as law-abiding citizens support 100%. We can't wait to hear what the Constitutional Court will say regarding your application. All the best. Well, that's it, folks. That's my reaction to that video. I have a video as well for the Public Protector, a reaction to the Public Protector's interview. Do not forget to like, subscribe to the channel so that you may receive as many videos as I make. I try to make at least a video a week for this particular channel because I've got other channels wherein I do something different. Okay, have a lovely one. Enjoy.